Hello, Leonard Lang here, and I'm speaking to the California Beverage Container Recycling Program, a program that's seriously mismanaged, and I'm out here today to explain some more background and why we have these problems. Under Save the Bear, I have regulations, laws, and bureaucracies. We're going to focus on the bureaucracy here today. And in February, I sent to the governor's appointment people a request to have an appointment removed. And that was the assistant director for recycling within CalRecycle, a person who's over in charge of the division of recycling. That's our Beverage Container Recycling Program. It's seriously mismanaged. So the first letter I sent in, we've had a lot of publicity on the closure of recycling centers in this state, and it was basically due to one company mismanaged and closing hundreds of them, many hundreds. But what isn't known is that a lot of good recyclers are being put out of business by the department. So that's what I addressed in the first letter. And in the issue that I pointed out is that CalRecycle denies due process, and the whole process itself denies separation of powers. Because if there's an adjudication, it's all within the agency. Okay, so that was in February. In March, I requested that he be removed because of an underground notice. Now, he was very familiar with that underground notice because he had to submit the letter to the Office of Administrative Law stating that they had done something wrong. They had created and imposed an underground regulation, and they promised to stop. And they have never stopped. I've called it the underground regulation from hell. They continue to use it. And we sent them a more recent example of its use. The staff is still trained on it. It's still posted on their website. It's an abuse of power. It's an abuse of the Administrative Procedures Act. And since this guy's an attorney, it's a good example of him not understanding the law and his authority under that law. Then, right around the same time, I sent in a letter that they had failed to adopt what are known as prepayment controls. Now, they have withheld money, and I contend it's illegally, from recyclers and processors. And the law does state that they can implement prepayment controls. I don't think they can do it legally, but the point is they've never done it. So in the audit of 2014, the auditor said, you must adopt these regulations. You cannot continue to do this. But for 6 years, they have. So another example of somebody not following the law, not understanding the authority, and exercising an abuse of power, in my opinion. Okay, now we have, right at the same time, 2 years ago, legislature passed opportunity to create pilot projects, 5 of them. Last year they funded that with $5 million. In December there was a meeting in Sacramento regarding those pilot projects for anybody that was interested in it. And at that meeting, one of the participants at the meeting was complaining about how the department had made a determination to spread the money. Now that spreading was not in statute, therefore it was not authorized, and the person at the meeting, participant, brought that out. Well, the assistant director was sitting there, and it was turned to him to answer the thing, and he basically said, I don't care what kind of a back deal you think you made with Assemblyman Ting, you're not getting more than $1 million, and you won't find that anywhere in the statute. So again, the department's making a determination not supported by the damn law. All right, so the next one we have, a few days later, I sent in a request for his removal because what I consider to be an abuse of power and cruel and unusual punishment. They've done an audit on a little recycler, and it was what's called a handling fee audit. The people who do this aren't qualified auditors, and they have no procedures for this. It shouldn't even be allowed. But they made a determination that there were some mistakes in the records and that she should be removed. So they sent her a letter removing her from the program. It did go to a hearing, and it was immediately dismissed because the department had not recognized and obeyed their own regulations. They were treating this recycler as if they were on probation, and they had allowed that probationary period to expire. That gave this person a permanent certification. That means a permanent license. And now if they really wanted to get rid of them, they'd have to go through much more tougher standards. They'd have to go to administrative hearing. And they chose to do that. And so they reviewed 3 months worth of records where maybe this recycler made about $5,000 a month if she was lucky, and they wanted to charge her $844,000 in fines and penalties, plus court costs and plus investigation costs. Could end up $900,000, $1 million, and all they did was review 3 months worth of records. How they did that? $2,000 for any minuscule record-keeping issue. So maybe I bought, maybe the recycler bought 10, 20 bucks worth of recycling from the public, and they decided that that was a $2,000 fine. And they did it over and over again, enough to get $844,000. Clearly an abuse. Then I sent one a few days later. There's another case going through the courts, and in this case, they went after a processor. That's who buys from the recyclers for $80 million. Now, $80 million represents what they were given to pay out to recyclers over 5.5 years. They don't keep that money. So that clearly is an abuse right there. But then they popped on another accusation, a civil accusation, for $500 million. So there's $580 million for a business that, who knows, maybe they made $10,000, $15,000 over the 5.5 years, but clearly it's an example of cruel and unusual punishment and an abuse of power. And the law says that they are to consider the ability to pay. They're supposed to consider the extent of the violation, and clearly they do not do that. So now we have another issue. They continuously reduce or deny claims, and which without adjudication, without due process, and so I requested his removal on that basis. Again, he doesn't understand the law. Now, in May, I submitted a Public Records Act request, like Freedom of Information request, and I got a document finally that showed me that the department had been misinterpreting the regulations ever since somewhere there was a change in leadership, a change in management. When a recycler is charged with violations and given an opportunity to have a hearing, they're supposed to be able to have it like a speedy trial, a speedy hearing, and it's supposed to be within 20 days, and that's exactly what the document I got said. But that's not the way they've been operating since I've been dealing with them, and that goes back to 2007. What they say is all they have to do is establish the hearing within 20 days, so they could do it for 2-3 months out. And in fact, it's common. Oh, well, so-and-so's on a vacation, so-and-so's not going to be available, so it's at their convenience. I merely reflect on Gladstone's quote in the 1850s, justice delayed is justice denied. These people can be shut down without income and not be able to pay the bills, not be able to pay defense. It is clearly an abuse of constitutional rights. Okay, now on 7/23, I sent them another one that said I've got I think about 6 or 7 Public Records Act requests every month. Recently, I get an update every month that they're still working on them, and it should know more in a month. And every month they say we should know more in a month. We're working on them. they're clearly trying to deny me these documents because they will be incriminating. They will show how badly they've been operating. Now, the prepayment controls, where they denied the money, they were told to adopt those regulations by the 2014 audit. Were told that what they were doing was underground. It wasn't authorized, and they have constantly stalled that issue. In 2019, they said they were going to get to it in February of 2019. They didn't. In this year, they say they're going to get to it in November. Now, my belief is that they will do it in November because I'll bet that the assistant director retires by then, and he won't have to deal with it. It'll be somebody else's problem, and it could go on for years again. In the meantime, recyclers are damaged without authority, without due process, and even if they get into a hearing, it's generally done without separation of powers. Last thing I want to bring up. Recently, now this is within CalRecycle, it was a separate issue, but it was a rulemaking issue. They attempted to adopt regulations covering organics, and the Office of Administrative Law, which oversees the process, rejected their package. And on almost 40 occasions, they said they failed on clarity standards. Regulations must be clear and understandable in everyday language, and they had almost 40 instances of lacking clarity. Then they had 2 issues of lacking authority. That means they're doing things that, again, the law didn't authorize them to do. And then last, there was about roughly 7 procedural issues where they weren't following the procedures of the California Administrative Procedures Act. So this just shows an overall problem with the department. All the previous other issues shows why the assistant director should be removed before his retirement. He is the scandal. This should never have been allowed, and it shows that the ship is running without somebody at the helm. And currently, CalRecycle has worked without a director since December. So, Governor, you need to appoint a good director who understands the Administrative Procedures Act, understands the law, and understands how to manage and motivate people. And you need to get rid of this assistant director as soon as possible. And Leonard Lang, CalRecycle, it's an agency in chaos. We'll have more on that later. And I thank you.